Yes.
Item number 6.
Hmm?
Regarding item number 6, I have prepared number 1 also. Item number 3 is there. So, for the timing one.
Which one? Item
Item number 6.
6. Okay.
For the timing.
No, please, madam. I beg to mention item number 10, 12, 14, and 15, madam.
10, 12, 14, and 15.
Yes, madam.
What one?
My lord, the CD was called for, my lord. In fact, my lord, what I have been informed is that another bail application has been filed before the special judge, my lord. And the order has been reserved, which is to be fixed on 20th, after tomorrow, my lord.
Mm.
So he has returned the CD, my lord.
Mm.
Therefore, may I humbly pray, my lord, if the matter could be fixed on 21st, my lord.
Who is the petitioner?
Mr. Pangeng, my lord. I have already informed you, my lord.
Mr. Opada, special PP. SIC
My lord.
submits that. On the last occasion, the CD was called for. Over. Same matter relates, similar matters, which has been filed before the learned special judge.
My lord.
What is special judge?
PC Act.
PC Act. PC Act. Wherein the CD has been submitted and the order for the bail has been reserved, which is likely to be delivered by tomorrow, day after tomorrow,
28th, 20.
by 20/03/2020. Accordingly, press for listing the matter after
On 21st, my lord.
21st.
Mhm.
Praise the Lord. List this matter after on 21st,
21st, my lord.
0/03/2020.
CD may be called for.
Yes.
Public.
Lordship, I beg to mention item number 23, Your Lordship.
23.
On behalf of M. Biswas, Your Lordship.
Hmm?
Lordship, on behalf of M. Biswas.
M.
Biswas.
Vishwas.
Yes, Your Lordship.
23.
23rd, Your Honor. Item number 23.
23. There is no M. Vishwas.
Uh,
SK Das.
SK Das name has been mentioned, but the council is M. Biswas, Your Honor.
Okay. Then
He had
what-
prayed that this matter may be kindly fixed after Bihu, that is on, if it can be taken on 24th of April, Your Lordship.
objection, no.
Actually, I was trying to object, but since outsider advocate, so let the matter be fixed for admission hearing. This,
Miss MS
Arthur.
Arthur, then counsel appear on behalf of Mr.
24.
M. Biswas.
M. Vishwas. Press that matter may be listed after
Bihu, Your Honor.
Bihu
Vacation.
vacation. Mr.
On 24th, Yes.
Ajit Tarak has no objection.
Sir.
Praise the Lord. List this matter on 24
yes,
April
April.
04/2024. MS, you are appearing.
What is that, Lordship?
L. Hage for the additional PP, London additional court. State present. Huh?
Lordship, there is an interim order that may, if that may be continued, Your Lordship.
That's why most probably, that's why he was trying to object.
Yes,
Yes.
Interim order was the additional continued.
no,
Yes,
To mention item number 26, Your Lordship.
26.
Can I take up this matter tomorrow?
Not tomorrow. Maybe on Thursday. Thursday or Friday?
Thursday.
Huh?
Thursday.
Or Wednesday? Wednesday. On the prayer of MS Arbasa, London State Council. This matter on 20/03/2020.
My lord, I beg to mention item number 5.
Yes.
I'm for the respondent.
Yes. You're not interested in the compensation? When do you want?
After 3 weeks.
Huh?
3 weeks.
3 weeks?
Yes.
On the prayer of Mr.
Pardon?
Your name, please?
Oh, M. Khambo.
Huh?
M. Khambo on behalf of leading counsel, Mr. R. Sonar.
Campbell, Learned Counsel appearing on behalf of Arsona. Praise for listing the matter after 3 weeks.
Yes,
Praise the Lord. List up.
much obliged.
May I, Lordship, I would like to mention item number 11.
11. Yes.
I'm on the behalf of H. Boris.
H. Burua.
Yes,
Yes.
the council is suffering from fever, so he couldn't come. So kindly this matter may be
On the
adjourned
prayer
for
of MS.
2 weeks.
So and so learned counsel for the learned counsel appearing on behalf of Mr. H. Burua, who informed that Mr. H. Burua is not keeping well, for which she prays for listing the matter after 3 weeks.
2 weeks.
2 weeks.
Also, I would like to mention item number 13.
13.
The leading counsel is from Guwahati. Due to some emergency, he couldn't come.
Indisposed, huh? On behalf of T. Das. Same order, indisposed. List after 4 weeks.
2 weeks, sir.
2 weeks, huh?
An interim order may be continued.
Both the cases.
No, sir. Only in item number 13.
13, huh? Interim order, interim bail granted earlier September. Interim bail, it is interim bail.
Yes,
bail
Lordship.
to continue till next date.
Yes.
Your Lordship, I beg to mention item number 25, mentioning on behalf of Matokato.
35,
25.
25,
Yes, my lord.
huh?
Yes, my lord. Mentioning on behalf of M. Kato, we have taken consent from the other party also.
Where?
Sorry, my lord.
Why you are mentioning?
Instruction from the senior.
Huh?
Got instruction from my senior.
There must be some ground. Is please for hearing.
My lord.
Whatever the petitioner, appellate,
We have taken consent from this also.
Mr. So-and-so, learned counsel, appearing on behalf of Mr. M. Kato, learned counsel to the respondents, comma, on consent from the other side, prays for listing the matter after 2 weeks,
Yes,
3
my lord.
weeks,
3 weeks.
4 weeks,
3 weeks, my lord.
3 weeks. Prays to list this matter after 4 weeks, 3
Much
weeks. Okay.
Much obliged.
Yeah, your lordship. Your lordship, I beg to mention item number 3, your lordship.
Item number 3.
Yes, your lordship. Your lordship, here in the leading counsel is my senior counsel, Mr. Pitafo.
Ah.
He is out of station.
Item 3,
Yes, your lordship.
Pitafo.
Yes, your lordship.
His name is not reflected here. Item 3, are you sure?
Yes, your lordship.
Is there? Item 3, okay. On the prayer of Mr. So-and-so, learned counsel appearing by Mr. Pitafo.
Your lordship,
List this
kindly
matter after 3
maybe
weeks.
fix on your lordship, 20, on 20 of this month.
21,
Much obliged.
21/3/2020.
May I, your lordship?
Yes,
Your lordship, I beg to mention item number 9
9.
on behalf of conducting counsel Ansuma Daimari. Subrata Chaudhary, your
Hmm.
lordship. Your
Mention
lordship,
be-
yes. Matter may be fixed on 22nd March.
Mention is made on behalf of
Subrata Chaudhary.
Mr. S. Chaudhary, learned counsel for the petition for listing the matter after 1 week. After a
22nd
week.
22nd March.
Is there any interim order?
Yes,
21, 21st,
22nd.
22nd Friday, no. Thereafter, 26.
Much obliged.
Your Lordship, I would like to mention item number 21.
21.
On behalf of Subukoyam.
21.
Yes, Your Lordship.
On the prayer of Miss MS So-and-so, learned counsel appearing for Mr. S. Quack.
The item may be fixed
Counsel.
after 2
List
weeks.
this matter after 4 weeks,
No, 2 weeks, Your
2
Lordship.
weeks.
Your Lordship, I'm on behalf of respondent.
Mr.
Uh,
So,
pleadings are completed in this matter. Matter may be fixed for hearing.
we'll see. This chapter, 2 weeks, 4 weeks,
2 weeks.
2 weeks. Mr. So and so, present, correspondent, huh? Yes,
I would also like to mention item number 1.
item number 1.
Yes, Your Lordship. That
Say,
it,
on behalf, appearing on behalf of Mr. S. Koeng so and so, huh? Letter consequent.
much obliged.
After 3 weeks,
No, 2 weeks, Your Lordship.
this one, 2
Yes,
weeks.
Your Lord.
Ah.
Much obliged.
If I may please, Your Honor.
Yes,
I beg to mention item number 18.
18.
In this case, Your Honor, we just received the paper book a few days back.
Huh?
The matter may be fixed for hearing after 4 weeks, Your Honor. We received the paper book.
On the prayer of MS, huh?
Item number 18 and
I think class it for preparation of paper book.
No.
LCR is there.
item number 17 and 18. 17 and 18 are AB, Your Lordship.
No,
18,
18 is
no,
criminal
18 is
appeal.
criminal appeal.
16 and 17 is AB.
Only.
18 is criminal appeal.
Criminal
Only
appeal.
being numbered. in
What
the-
is your prayer?
We've received the paper book. We will
Huh?
be given some time for preparation. Hence, the matter may be fixed after 4 weeks, Your Honor.
We'll see.
We have received the paper book a few
Paper
days
book
back.
has been, is prepared.
Yes, Your
Huh?
Honor, we've received it.
Is MS so and so learned council for appellant.
For appellant.
For appellant. So means she has received the paper for which she requests 2 weeks time to go
4
through the
weeks.
same. 4 weeks.
4 weeks.
4 weeks. For which she prays for listing the matter after 4 weeks. List after 4 weeks.
Also,
Praise the
item-
Lord, list after 4 weeks, huh?
Also, item number 19, Your Honor. I'm appearing
19.
on behalf of Mr. D.K. Dury.
Huh?
I'm appearing on behalf of Mr. D.K. Dury.
DK Devi.
This case may be fixed on 21st of this month, 21st of March on. He's for the respondents, and affidavits have already been filed on behalf of respondent number 1, which will also suffice for respondent number 2.
Who appears for this petitioner? Mr. Tara? Item 19.
Mr. Binter Picha is appearing and we've taken his consent, Your Honor.
My younger is handling.
On the prayer of Miss MS so and so. Donald Council
Okay,
appearing on
quick,
behalf of
yes.
Mr. DK.
So when you are-
DK Devi. List
Huh?
this matter after 3 weeks.
21st March. Okay.
21st March.
Why fixed it? Special preference?
I've been instructed by Mr. D.K. Dury to take it.
On what authority?
out
Un-
21st.
Under what authority?
I believe he will be available on that day, Your Honor.
21st. huh?
Out station advocate.
Deeply obliged.
That's
May I
it, what
plead,
is
my
this?
lord?
Yes,
My lord, as per the last direction, I have taken a step up in the private respondent number 1
yeah.
and pro registry, my lord, but it
Yes.
is not reflected. The step which I have taken, it is not reflected. So, my lord, I may be allowed to take a fresh step.
Your lordship, otherwise the issue is, your lordship, they are assailing the order of the learned court below, declining their prayer for determination of the age. So that order itself is a final order.
It's appellable order.
My lord,
It's a final order. So
That's
now,
why it's an appellable order.
yes, it's appeal and revision which is provided under the JJB Act itself, your lordship.
Withdraw. Well, appropriate application. Criminal petition is not maintainable.
yes, my.
Huh?
Otherwise, for
Why
them,
it's
there will
not
be delay.
necessary? File an appeal or revision, whatever is
Yes, sir.
applicable. Right?
Right. Yes,
Heard Mr. Entazi, learned counsel for the petition. Who prays for withdrawal of this criminal petition on being not maintainable. List of, with a liberty to file.
yes,
appropriate
my lord, liberty to
application.
file afresh.
Mr. D. Edison, Senior, that's it, additional public PP present. Prayer of Mr. Enter the London Council for the against allowed, and accordingly, criminal petition is stays closed and disposed of.
All right, my.
On withdrawal, huh?
Ran for a respondent.
Yeah,
Lordship, there was some miscommunication. We were instructed that this matter would be adjourned by the respondent. But
Okay.
since then, there was no such communication. We are seeking adjournment. in
otherwise
this matter.
very voluminous.
Yes, your Lordship. So if
Why,
in
why
that
is
case,
so voluminous?
no, your Lordship, I
Huh?
have to go through.
Reports are there. Report. Big. Okay, no, not that one. Right. So what is to be done today?
Lordship, if this matter can be adjourned for today, your Lordship, and we can fix this matter for hearing.
Sometime in April then, madam.
April,
After Bihu vacation, your Lordship, after election, if this matter can be fixed.
after election.
19th Bihu, anyways, vacation is till 19th, your Lordship. So it's either Bihu or either.
Why you should consider about the election? Okay. On the prayer of MS Arthak Land Council for the petition, list this matter. Appellant, sorry, respondent. You are appellant.
No, no.
Appellant. List this matter after Bihu vacation.
Yes, sir.
Mr. D. Learning Council for appellant present.
Much of.
Where's the stage?
Your Lordship.
What is the stage?
Lots of hearing. LCR has already been received.
It's okay. What is the stage?
State Lordship trial has already commenced.
Ah,
Now the accused has been in the.
what is your ground for bail?
Ground Lordship? The accused is in the.
Why don't you approach the trial court?
Lordship,
Why don't you approach the trial court?
Lordship, since Lordship aware that there is no session court sitting currently at the Alo,
Hmm.
the difficulties is that the jurisdiction has been conferred to the session court of the
Pasigat.
Pasigat. So
Go
it
to
is
Pasigat.
difficulties. Lordship, on that day when this application was moved,
Hmm.
the session judge of Pasigat was also on leave.
Hmm.
So Lordship, here,
Well,
the Lordship,
next week,
even-
you will be there,
Lordship,
is it not?
but of course, Lordship, this court has also jurisdiction. Since Lordship,
It's 439.
yes, Lordship, 439. Since the accused person in the custody since last 104 days,
Hmm.
Lordship, if we go into the merit, just before merit of the case, Lordship, here, the present accused is a wife, lady, not actually wife, since both are mutually separated by the another co-accused, main accused person, Tony Lolen, who is in the custody.
Hmm.
They solemnized their marriage in the year 2006.
Yes.
Out of their wedlock, they have begotten one son, minor son, who is presently under the caretaker of the wife,
Hmm.
present accused applicant.
Hmm.
And since 2016, both have mutually separated, and thereafter they never had any contact. But what happened, Lordship, on
2016.
Yes, Lordship.
Hmm.
What happened on 4/12/2023, on the day of ill-fated day incident? The
Yes.
elder sister of the accused, main accused, Tony Lolen, he informed the present accused lady,
Hmm.
saying that the marriage for Tony Lolen and the deceased person has been fixed on 20 December. And thereafter also informed that the deceased elder brother are retaining Tony Lolen for transfer of certain properties in the name of the deceased. Accordingly, since the accused person, because he's taking care of the minor son of the both accused person, so he went to the residence of the accused person, main accused person in the disease. And the said incident, Lordship, may I take you to the charge sheet? Page number 45, para 2 of the charge sheet, where it is clearly reflected the CC
Just before that,
footage analysis.
before that, let us see the FIR. Where is
Yes.
the allegations against?
Yes, Lordship. FIR is page number 17, Lordship.
Yes. Any specific allegations against you?
Lordship. May I read the FIR?
Hmm.
Page 17. FIR against Tony Lolen, son of Sri Huta Lolen, first wife of Tony Lolen. Here, first wife is the present accused applicant, Lordship. And first son of Tony Lolen and elder sister of Tony Lolen for killing my daughter, namely Miss Julie Ruchi. With reference to the above, the undersigned begs to state that her deceased daughter, namely Miss Julie Ruchi, aged about 25 years, got married to Tony Lolen in and around year 2020 and started living with him. And few months of marriage, Tony Lolen started torturing my daughter. And on many occasions, the matter was resolved amicably in presence of witnesses. Again, last evening on 4/12/2023, elder sister of deceased, namely so-and-so, received a phone call from the deceased at around 5:30 p.m. And the deceased informed that first wife of Tony Lolen,
You are the
was-
first wife.
yes, I'm first wife,
Okay.
has arrived at her residence and forcefully asking the deceased to vacate the house. Otherwise, the deceased will face their consequences. Again, at around 6:25 p.m., second phone call came from deceased to her elder sister, stating that elder sister of Tony Lolen has verbally warned her that she would also come to her residence and forcefully remove her from the residence. And further, first son of the Tony Lolen has warned the deceased not to give birth to any male child, as it will divide his share in property. And if any male child is born, he will kill him. Again, at around 5:30 p.m., first wife of Tony Lolen had called my brother, namely Lidu Ruchi, warning that he must take back her sister from residence of Tony Lolen, otherwise she would face dire consequences. Second call from deceased was made to my brother at around 7:30 p.m., informing that Tony Lolen along has started brutal assault on her and she is injured badly, and upon death, my brother had advised the deceased not to escalate the matter further, and my brother will come next day to resolve the matter amicably. Lastly, at around 1 a.m. this morning, I received a phone call from police of Alo Police, informing me that my daughter, namely Julie Ruchi, has been brought dead at General Hospital Alo and asked me to come and see the dead body. Upon reaching there, I found my daughter in clothes full of blood, and there were injury marks of brutal assault from upper neck, shoulder, till abdomen part. Bruises on right hand, face and neck, and disease was bleeding from lower abdomen, and there were also cut marks on left toe. This is the FIR, Lordship. Now, FIR reflecting,
You went to her place.
yes, Lordship.
This is place.
Yes, Lordship. That is also clearly reflected in the CD
No, when you,
Yes.
when you have mutually separated, when 2016.
2016. Wait,
Then
then
why you had to go there?
I am with the son, Your Honor, minor son.
Okay.
I was informed that there is a property distribution is going on. Therefore, I taking to my son, first son, enter into the residence of accused person and saying that property should also be kept for person, Lordship, who is minor right now.
Hmm.
It was only, Lordship.
Hmm.
Thereafter, we left the residence. I entered there at 5:20 p.m. and after 40 minutes, I went back.
Hmm.
That is clearly reflected in the CD also, Lordship, after CC footage analysis.
Hmm.
May I take you to the CD? Lordship, sorry, this one, charge sheet, page 45, para 2, Lordship. Page 45. Para 2.
Forty-five.
45.
Yes.
Para 2. May I read?
Hmm.
During the course of investigation, I have scanned the CCTV footage of ill-fated evening on 4/12/2023, which was collected from the house of Sri Tony Lolen, the main accused person, at Old Market, Alo. During the CCTV analysis, it is learned that
at around 17:18, means 5:18 p.m., Elise accused Tony Lolen came out of the house and again entered the house at around 17:20, Lordship, 5:20 p.m., along with first wife, Srimati Garigata Lolen, and their elder son, Master Nick Lolen, 15 years. It is found from the footage that Garigata talked with someone over phone, and from her expression, it is revealed that she was arguing someone over phone. After that, she, along with her son Nick Lolen, left the residence of the Elise accused. They almost spent around 40 minutes. Means I entered at 5:20 p.m. After 40 minutes, means at 6 p.m., I, along with my son, left the residence of the accused person. And regarding phone conversation, Lordship, that is also corroborated by the statement of the elder brother of the deceased. When I entered into the residence of the accused person, he informed me that there was some agreement, the pressure from the family side for regarding the transfer of properties in the name of deceased. Accordingly, I took the phone number of the elder brother of the deceased from the accused, Tony Lolen, and I made a call from the residence only. And after 40 minutes, Lordship, I along with my son, left the residence. After departure of Srimati Garik Lolen and her son, that Julie Ruchi and Tony Lolen started argument and fight, wherein clearly seen that Tony Lolen assaulted Julie Ruchi several times.
This is not a case of abatement.
No, Lord.
302.
No, yes, Lord. In the statement of Sri Tony Lolen,
It's okay. What is the ground?
Ground Lordship,
Why you should be released on bail?
yes, Lordship. Lordship, since I am in the custody since last 104 days, charge sheet has been already filed. So there is no any further custodial custodial detention of the accused person is required. Moreover,
104
I have to
days.
prepare my defense also, which is not possible while in the custody. Lordship. And Lordship, since I am serving as a MTS as Government Middle School Hisam, so there is question of fleeing from the justice from bail after getting the bail.
Trial has started.
Yes, just started, Lordship, and there is a no prospect the conclusion of the trial since 17 witnesses statement of the 17 witnesses has already been recorded, and committal proceeding was already done. That I have enclosed on 27th committal proceeding was done. Matter was fixed on 4/3/2024, and again it was fixed for CC on 12/4/2024, Lords. So, Lordship, regarding the preparation of the defense, that I would like to place one judgment of our own High Court. The copy was already furnished in the last copy. Ferratian, Lordship. Ferratian. Page number 4, Ferratian.
Keeping the above.
Keeping, yes, may I read, Lordship?
Hmm.
Keeping the above principles in mind, now we will proceed to analyze the submission of the learned advocate of both the sides and also the fact and circumstances on the record and case diary so produced before the court by the CBI. I have carefully perused the petition and the documents placed on record and also perused the case diary so produced before the court, and I find the following. Number 1, FIR was registered on 12/6/2022 and the accused was arrested on 14/6/2022. The accused is behind the bar for last 84 days. In my case, it's been 107 days. The accused was working as a regional officer in NHAI in Guwahati before arrest. There was no any demand on the part of the accused, so and so. The learned counsel for the counsel has rightly pointed out at the time of hearing. The investigation of the case has already been completed and charge sheet has been laid before the Court of Learned Special Judge, CBI Guwahati on 10/8/22. Trial of the case is yet to be started. The charge sheet has been submitted, citing 103 witnesses and referring as many as 161 documents. And as such, there is no immediate prospect of conclusion of trial. Then 7.
9.
Yes.
Roman 9. That's all.
Yes.
Hmm.
Since the investigation has already,
That's all.
yes, completed and charge sheet has been laid before the court, there is no scope of hampering investigation or tampering the witness. Now trial will start and accused has to prepare his defense.
Hmm.
This is the ground rules. And everything is, charge sheet, since the charge sheet has already laid before the court,
Anything else?
that's all.
Yes,
Lordship,
Not to
if I
you.
may,
we'll hear her first.
there is a small prayer, Lordship, if I
What?
may be allowed. Lordship, today I'm appearing on behalf of the complainant.
Hmm.
Since we have not filed the Wakalatnama and only yesterday they came to know that this bail matter is pending before this honorable court. So the complainant has the objection why the bail has not to be granted to the alleged accused person. So in this case, I'm praying that if this matter can be adjourned today and can be fixed on any other date, Your Lordship.
Why? We'll go the records and we'll decide.
But Your Lordship, the complainant has the
You
objection.
assist her only.
Since we have not even filed the Wakalatnama only
No
yesterday,
worry, I'll allow you to assist her now.
then I have to take the instruction because the counsel is also not here, Your Lordship.
Ah,
The counsel who had been appearing for the complainant is also not before this court.
it will be just mere formalities.
That is
Either
there, Your
you
Lordship.
appear or no appear.
Otherwise,
decide.
this matter also can be taken up tomorrow, Your Lordship.
No, it's. Yes, we'll see. Is it not related to me?
Lordship,
Since the petitioner accused is is it hopefully it's not, they are not related to me.
no. They are from the ALO.
That's why I'm asking. Village.
Now, Blaze, Lordship,
Walk.
walk. Not related, Lordship.
Yes, madam. What is there? You have, interrogation is, I mean, the investigation is completed.
No, sir.
Charge sheet has been filed.
No, sir.
Trial has started.
No, sir. We have also called LCR also, no, sir.
Yes, what is the LCR? Where is the LCR?
No, sir.
Same thing.
Find out what is there.
When close the affairs.
You have enclosed the charge sheet.
Yes. Entire charge sheet along with the.
What else will be there?
Yes. Of course. Lordship.
No, sir. 14-3 is fixed for appearance, Lordship. Before the,
14-3.
yes, Lordship. It is today is 18, Lordship.
Ah,
They have appeared, Lordship, before the Honorable Court of District Session Judge Alo. But as per my this London Courts Counsel, his submission was that the Alo this court was not sitting. So maybe it is.
anyway, it's
No, sir.
before us, we'll
No, sir.
consider on merit.
Because no, sir, as per the
According to you, it should be, he should file the application before, trial court.
no, sir, he
that is
should,
what you are
Lordship,
trying
yes,
to
Lordship,
submit,
because
huh?
session is
What is the-
jurisdiction is there,
What is
Lordship.
the law? What is the law that he should approach?
No, because Lordship here,
Initially, your bail application has been rejected.
Two bail application has been presented.
On what ground?
First
Saying
one
that,
was
it's
the
the
investigation
investigation is,
at early stage.
then second one,
And another ground, it was rejected saying that there is no any change in circumstances.
change in circumstance.
Change in circumstances.
You could not have filed the.
Yes. Thereafter, in the meantime, I could not avail the 167 because charge sheet in the meantime has been filed,
Hmm.
but there is no sitting of the presiding officer. That is my difficulty.
When it was filed,
Charge sheet
after the completion or before the completion?
before completion, before 90 days.
Huh? Okay. No, suppose, if they file the charge sheet after 90 days,
Yes.
even if you are still there, the date of filing will be counted to have the default bail. That's why I'm asking for that.
No, Lordship. Lordship.
Before
after-
the completion of 90 days,
Yes.
charge sheet has been filed.
Charge sheet has
So
been-
in that case, it's no
No,
issue. But
no
then, in case, suppose, if you are still in custody,
Yes,
I mean, even 1 day or 2 days before,
yes.
after the completion of 90 days,
Yeah.
in that case, you have the right to claim for default bail.
Yes.
You show us anything that at this stage, even after 104 days,
Lordship,
she should
medical,
not be, she is not,
Lordship, medical report also awaited, Lordship.
hmm?
Medical report is also awaited. As per this. FSA report, Lordship.
That will, we have not asked for medical report.
Lordship, as per the.
Charge sheet
Lordship-
clearly says
Yes, Lordship.
that she came there, but after this they left. Then they started fighting, the main accused. When there was a fight and all, she was not there. That's why I'm asking, is it a case of abatement? It's not a case of abatement.
No, Lordship.
It's 302 and what is the other section?
306, Lordship.
And in charge sheet, Lordship, I have enclosed the inquest form also, whereby the expected the cause of death was also clearly reflected.
No, we'll not go into all this.
Yes, yes, Lordship.
We just prime facie
Yes,
the,
Lordship.
the involvement and what's the sections under which you have been charge sheeted?
Charge sheet, Lordship,
Final one.
charge sheet was Lordship filed and the section 302, 120B and 506 and S 34.
120B, you are there.
Yes,
506.
506 criminal intimidation
Okay.
and section 34 was it, sir?
Yes.
Lordship, as per this charge sheet, Lordship, is this below, Lordship, it is reflected that supplementary charge sheet was submitted after receipt of the FSL, Lordship. FSL report is awaited. That is only my ground, Lordship, because, Lordship, here already he sees, Lordship.
Whatever
inside
the right to defense. Yes. Violation of right to defense.
That is there, Lordship. That, Lordship, I leave it to court, Lordship, as.
All his ground is, one is the investigation has been completed, no
Lordship.
custodial information.
Lordship.
Investigation has already been completed, charge sheet has been filed. Now, continue to putting her in the bar will deprive his right to defense. That's all.
Lordship, that is there,
And
Lordship.
admittedly, charge sheet has, the trial has started.
The only, Lordship, the
We are
FSL
not
report.
saying anything about involvement or otherwise of the matter of the accused. We are only bail jurisdiction.
The other, this statements of the other witnesses also, her name is revealed, Lordship, and as per
It's a
Lordship,
matter of trial, ma'am.
Lordship, that's why, Lordship.
No, at this stage, initial, it was right, say 302, investigation was in its initial stage, so right. Now, charge sheet has been filed. By putting her in a jail, what the investigative authority will get from that? Suppose FSL report, you are yet to receive the FSL. If something comes out, can she do anything on the FSL report? It's beyond her reach, right? Then,
Lordship, I'm seeking.
then we'll pick it up by following the principle of natural justice.
Yes.
Whether it's tomorrow you may say that I have not been heard,
That is.
but I can hear you now also, if you have anything to submit.
Under
We are
30,
taking the instruction, Your Lordship, because
What instruction?
from the council itself.
You take the petition,
No, that is there, Lordship, but also I have to go through the reports. That's why
or
I'm
Mr.
saying
K.
under 301 CRPC, Lordship, is Lordship aware?
Okay. Because this court will tomorrow, will dispose it tomorrow,
Yes,
no adjournment.
No adjournment, but at least the hearing chance may be given.
5 minutes in a custody is very, I mean, very, you can understand. But can we take up at 2 o'clock so that you can argue?
Today, your lordship. Tomorrow, your lordship in a daily.
In that case, Lordship, I maybe grant interim bail.
It's only for a day, your lordship. So tomorrow, if it is taken up on a regular basis.
Even for the day also, Lordship, of course, my Lordship is granting, otherwise they have no right. There is no any right,
But I have not decided whether I'll be granting or not. I want
by
to consider
allowing
it
time,
today,
Lordship,
yes.
for allowing time, Lordship.
We'll take it up tomorrow. It's okay. Heard Mr. K. Lolan, applicant. Also heard MS El Hage, London additional people for the state. Next period. MS Arthako, London Council. The informant is a party here.
No, not at all. This is a
How can you,
Since the.
what is your right of audience?
This way, Lordship.
Lordship, I am the father of the disease. Your lordship.
You are not a party
I am not a.
and it's
party,
not
but-
necessary also.
No, but.
Yes.
if your
Only
lordship-
you have a, you may assist the PP only.
That's why tomorrow, your lordship.
You will assist tomorrow.
Yes, tomorrow I will assist. you.
No, PP having the records and everything, if she doesn't have
But you-
anything to submit,
That is the, I believe your lordship.
except
from-
the waiting for the FSL report,
Yes, your lordship.
what?
There
things-
might be other
what-
grounds,
what-
your lordship.
what
That's why I
grounds?
believe. There might be some other grounds which that has not been brought before this honorable court. That's why your lordship. Tomorrow it can be. heard.
Lordship?
Even if it is disposed tomorrow.
Beyond
Can be-
that seat, Lordship, there
so
cannot
it's,
be any ground.
Learned Council submits that she has a power to, she has
Her
been authorized
objection
to appear on behalf of the informant. Please stop. On such submission, Mr. K. Lolan, learned counsel for the petitioner, vehemently objected to the prayer that she has no right to audience. As the matter, in this bail matter, the offense involved is under 302. However, at best, she can assist the public prosecutor. At best, huh? Having considered the submissions by following the principle of natural justice, the matter will be listed tomorrow so as to enable our London Council to assist the additional public prosecutor. We'll dispose it up tomorrow.
Yes, Lord.
Will not hear you, you assist her.
Yes, yes.
You give her whatever, I mean, the materials or the bullet you have in the evening, so that she can prepare.
Yes, Your Lordship, I'll do it. Much obliged.
Deeply obliged.
Yes.
May I, Your Lordship? Your Lordship, matter may be adjourned for today.
Why?
On the ground that Senior Counsel K. Tama, he is out of station, Your Lordship. Due to some personal difficulties, he is out of station today. And he has also submitted his leave of absence also. In-
This criminal petition is for quashing.
Watching of the
Yes.
FIR,
Why? What is the FIR?
FIR page number 20, Lord.
What is the allegation?
Allegation, fraudulent of rupees 4 crores 15 lakhs.
According to you, it's a civil dispute.
Yes, Lord.
What is the latest judgment last week?
Lord.
Get the latest judgment last week.
Yes, Lord. Ramji Batra, State of Uttarakhand.
It was delivered last week.
Yes. And Naresh Kumar and others. This is what.
Sir, this is of 2012. I said last week, judgment by Supreme Court.
Yes, Lordship, Sarabjit Kaur, state of Punjab.
This is of two, it is
Yes,
not
Lordship.
2012.
Yes, all our allegations are same, Lordship.
Sarabjit Kaur.
Naresh Kumar also, Lordship. Para 13 and 14, Lordship.
What is the fact?
Lordship.
Tell us the fact of the matter.
Yes, Lord.
Don't refer, just tell us.
And Lordship, allegation for fraudulent rupees 4 crores 15 lakhs. 4 crores 15 lakhs
Allegation,
allegation and project for
transaction of,
national highway, Lordship,
yes,
road constructions,
okay.
and the National Highway Infrastructure Development Corporation Limited have bid an advertisement for contractors, Lordships. And accordingly, one Sharna Wilcon Private Limited, this is the farm.
Have you entered an agreement with the
Yes, Lordship.
informant?
There are 4
Okay,
agreements.
was there the delivery of money
Yes, Lordship.
after the agreement?
Yes, Lord.
You have received for,
Yes, Lordship.
then,
Lordship, matter may be come forward when last agreement was done between among the Hadrasan versus Hadrasan Construction India Limited versus SNY Builders Limited, Lordships. And matter come that come to the knowledge that the installed substandard machinery was expensive, highly expensive, Lordships. Then violation of this agreement was come, and accordingly 40% of rupees was lost. There are 5 parties, Lordships, and among them there are 4 agreements. All are in Delhi. Agreement was done in Delhi, and matter is arbitration, Lordships.
what do you say? It's a purely civil dispute.
Your Lordship, on the last occasion, they have submitted, they are going to file an additional affidavit.
Yes, already filed, Lordship.
And we have received today itself, Your Lordship, just hour before, Your Lordship. So,
And these pleadings are required in the 482 petition.
so matter maybe fix for after some,
We'll
for
see
some-
the records only why pleadings are required. Exchange of pleadings are required.
There are order that are 21/1/24 Lordship, were directed to produce the case diary also Lordship. But as per instruction Lordship, the charge sheet already been submitted.
We'll call for the records only.
Yes, Lordship. And
Not
another
Mr.
thing is
Twain,
that, Lordship,
other
and next that is 64 JMC UPR, Lordship, here.
It has been issued.
Yes, no, another summon is also received by the accused person, Lordship, under section 160 CRPC. In this matter, already proclamation was proclamation non-bailable warrant already issued by the JMCL court, Lordships. But subsequently, on 70/2024, the IO have all again
Already,
issued.
the
Yes, Lordship.
copy of the LCR has all been found. Is there? Is there?
Yes.
Okay. There is no question of CD. Already the LCR has been called. It's there. Heard Mr. So-and-so, learned counsel for the petitioner. Notice has been issued.
Yes, Lordship, already issued.
We'll fix after some time. He wants to file and reply to your additional affidavit. Mr. So-and-so, learned counsel, appearing on behalf of the respondent.
Respondent number 2, Your Lordship.
Respondent number 2 submits that he has received the additional affidavit filed on behalf of the petitioner, for which he pressed for listing the matter after 3 weeks to file and reply the response to the additional affidavit.
In the meantime, Lordship, kindly stay the non-bailable warrant and proclamation order dated,
That we cannot.
Lordship. Then he is ready to appear before the IO, Lordship.
Huh?
He is ready to appear before the IO if
Go and
required.
File an appropriate application before the appropriate for recalling of the NBW. Not otherwise. What is there? This one. Praise the Lord. Praise for, huh? Praise the Lord. This matter after 3 weeks. You record the MS.
That may be fixed,
And have
Lordship.
your so be.
That may be fixed,
Additional
Lordship.
PP is present, huh?
That may be
LCL
fixed, Lordship.
received. Have you prayed for anything or stay of the NBW and the
Yes, Lordship.
proclamation?
Yes.
Here,
Yes, Lordship.
huh?
In this petition also, Lordship.
Let's see. Why so voluminous?
Lordship, yes, Lordship. And next are, next are 8, Lordship, page 921, 910 to 911, Lordship. Non-believable warrant, dated 28/11/2022.
No, what is the prayer?
Oh, pair in page 17. I'm going to pray, Lordship, may please that this call for the record, and issue notice, calling upon the responses of Mr. White and issuing on the affair dated so and so.
It's 21/9/2023. Huh?
Yes, proclamation.
Then 28/11/2022.
Yes, Lordship, non-believable one.
It's too late in a day. We'll consider next day.
Okay.
This after 3 weeks.
There are metaphysics depth, Lordship, because I am from
After 3
Guwahati.
weeks. Huh?
I am from Guwahati, Lordship. It's problem for me.
Don't you have a friend here?
No, Lordship.
You engage a good friend out there.
No.
You don't have a good friend here. All are bad.
Fixed net.
All friends are bad here.
No, not that. Nikita is my friend, Lordship.
Okay, she's there. She'll appear. She'll inform you when it will
No,
be
Lordship.
listed. After 3 weeks.
Fix a date, Lordship.
Huh?
Fix a date, Lordship. Fix a date, Lordship.
Will not fix.
Lordship, please.
After 3 weeks, will be listed. Huh? She'll inform you.
For the reason that their anticipatory bail application was rejected by the Learned District and Session Court, Tezu, by order dated 5th March 2024. Lordship, during the pendency of this instant anticipatory bail application, Lordship, there's a new development has arisen, Lordship.
Yes.
The complainant, victim, and accused has settled, Lordship, by compromise deed dated 14th March 2024. Lordship, if I may be allowed to place before this honorable court. Yes, Lordship, without wasting the honorable court's time, I'll straight away take Lordship to the compromise deed, Lordship.
What is the offense?
Attempt to murder, Your Lordship, 307.
Lordship, if I take Lordship to the straight to the compromise deed, Lordship, this is very clear where I am innocent, Lordship, because here the victim and the complainant has clearly acknowledged that I'm not involved in the crime.
Let's see the case diary. What is there? Case diary is there.
Just
Just keep it. What is the ground of your bail?
Lordship, my only ground here is that, Lordship, I'm innocent. I'm innocent.
Something different. New
Yes.
new ground.
Yes, Lordship.
Innocent is
Yes, Lordship. If I straight, Lordship, this
innocence in the vague, the ground.
Lordship, if I quickly take Lordship to this compromise deed.
Let us
very
see the
quickly.
FIR first.
Yes, Lordship. FIR is page number 13, Lordship.
Yes, you read the FIR.
Yes, Lordship. May I read, Lordship? This FIR is dated on 31st January 2024, Lordship. With due respect and with reference to the subject cited matter, undersigned like to inform you that I, Raju Thakuri, resident of Sanso, PS Sanso, my nephew, Denish Thakuri, son of Sanso, was working as a daily wage labor at Mecca, Ruin. At around 8 p.m., he left Mecca after receiving few calls. As he did not return on that night, we started searching him. We found him at Italy, that is Gia, next day on 29th January 2024 at around 9 a.m. Naked and seriously injured on bamboo field. I therefore request you kindly take the aforesaid matter seriously and further please to take a necessary action against the above said accused people as early as possible.
Yes.
So this is the FIR, Lordship.
Hmm.
This is the FIR where it has stated that his nephew was found seriously naked on 29th in the morning around 9 a.m. No name has been reflected yet here, Lordship. No name has been reflected. And Lordship, here, when we have approached the Lordship, before going to that, Lordship, the police has, I have enclosed on the page number 14, Lordship. Page number 14. On 27th February, Lordship. On 27th February, without any notice by the police, a wanted criminal poster was circulated in a WhatsApp group. I've enclosed, Lordship. I've enclosed. And Lordship, when 27 it was circulated, I intend to approach District Assistant Judge for anticipatory bail under 438. And on the next day, on on the next day, that is on 28 January or February, Lordship. My annexure number 3, that is page number 16. Page number 16, Lordship. I've been issued a notice under 41A. Only after I was made a wanted poster, wanted criminal in Shantipur PS case on 27th, I was in receipt of 41A notice by the police to appear before 29th, on 29th. The same was received on 28th, Lordship. The notice is dated 28 January. Must be typographical mistake by the IU. It must be 28. The same was received on 28. Thereupon having a apprehension, I have in a wanted poster, it was very clear that 307 and 34 was, which are non-bailable offense. Therefore, I have approached the District Accession Court, Lordship. District Accession Court, I have approached for grant of anticipatory bail. And the District Accession Court white order that the 5th May or 5th March 2024 has
Rejected your appeal.
Yes, rejected. If I take very quickly to the grounds of my rejection, Lordship. That is in page number 18, Lordship. Page number 18. If I quickly read, Lordship. Page number 18.
Page number?
18, Lordship. 18.
18.
18, yes, Lordship.
18.
Yes, Lordship.
Yes.
Yes, Lordship. Upon careful perusal of CD, after hearing the parties, it appears that IU has a reasonable circumstantial ground to suspect the involvement of the applicant accused in the pre-arrest bail matter, including non-cooperation of the accused despite notice was issued. An effort was made to contact with the accused through mobile phone, due to which the name of particulars of the accused under caption wanted had to be uploaded on social media on 27 and 28, seeking public citizen assistance of apprehension of the accused. Lordship, here the finding is this honorable judge said on 28, 27 and 28, it has been wanted was circulated in social media. On 28, I was in receipt of a notice. On 27th, before receiving a notice under 41A, I was made an accused criminal in wanted poster in social media.
Huh?
On 27, I was made a wanted, so in the social media, I was circulated as a wanted person in criminal case, in an instant case.
When
On 27, Lordship, if Lordship comes to my
you are directed to appear on 28.
yes, if Lordship kindly see page number 14. The same was published on 27th February 2024 in the social media, and I was received of a notice on 28th. One day after my wanted criminal poster has been circulated, Lordship. And the offense is very clear, 307 has been pointed out in the criminal wanted poster. Therefore, I approached the Honorable District and Session Judge. Therefore, what I'm trying to submit here is that the finding that non-cooperation with the police in spite of issuing a
Actually
notice.
correct.
Yes, Lord. Okay. So in spite, I was met a wanted criminal 27, and one I intend to approach because the same is non-bailable offense. On 28, I've been issued 41A notice. Therefore, Lordship, the finding by the Honorable Lana District and Session Judge here is incorrect, Lordship. And Lordship, the law in this, the legal proposition in anticipatory bail is very clear. And
What is
it's
clear? We're not clear. I'm not clear. You tell
Yes,
us
Lordship.
what is clear.
Yes, Lordship. I may be allowed to make submit a few citations in this regard, Lordship.
Tell us the facts first.
Yes,
You have
Lordship.
not completed
Oh,
the
yes.
facts.
Yes, Lord. Yes, Lordship.
Don't jump to the gun.
Yes, Lordship. Lordship, here the petitioner, in this case, the petitioner is a wage laborer who is earning his livelihood, Lordship. He is earning his livelihood. He has no criminal antecedent except the instant one, supporting his wife and a child. Supporting his wife and child, Lordship.
Have you appeared before the IO?
No, Lordship.
This was, you have received the summon notice.
When I received someone, I was in the district and session court approaching the court ground of anticipatory bail, Lordship. Because the same has been non-bailable offense.
No, you are directed to, you appear on 29th.
No, Lordship, 27, I've been made as wanted. Every person will be
It's
scared
okay,
of the
29
same, Lordship.
29, you are directed to appear. You moved the bail application on 5th of March. It was rejected.
Yes, Lordship, it was,
Where are you now?
we were gathering certified copies from the police station itself, Lordship. And Lordship, invoking 340, this anticipatory bail application is not actually will amount to the absconding, Lordship, if my humble submission. Because the law is very clear. When you have a remedy, you can invoke.
We'll come to the law.
Yes, Lordship.
Don't jump to the law again and again.
Yes,
I'm
Lordship.
not clear. If
Yes.
you may be clear,
Yes, Lordship.
unless you are clear about the facts, there is
Yes.
no question of, clear about the law.
Yes. Okay, Lordship, here, I'll take Lordship to my petition straight away then. Lordship, I am a permanent resident of Gia village. It is Ruing. I've enclosed my Annexure 1 as my AP card in order to show this honorable court.
Nobody is disputing.
Yes, yes, Lordship. Yes.
Then
The FIR was filed on 31st January 2024, Lordship. 31st January 2024, without any notice prior to circulating a wanted poster in this case.
it's okay, we are,
Yes. Yes, Lordship, I've been made as a wanted criminal. And when I see in the WhatsApp social media group, I've been made as a wanted criminal. On the next day only, I received a summon under 41A when I intend to approach. Since the offense is non-bailable offense, I've approached the learned district and session judge. And the learned district and session judge has the finding which I have already read out before this honorable court has rejected my bail application. Lordship. And Lordship, section 438 is very clearly says that obviously the nature of an offense which has been alleged has to be looked into one
it's
ground.
307.
Yeah.
Serious.
Lordship, Lordship, but the involvement, I'm here innocent, what I'm submitting, Lordship. And Lordship, and another aspect which to look into is that whether I will be fleeing from the justice upon the enlargement of my pet.
You have approached the sessions
Yes, we have approached the
court
section
under
court.
438.
Yes,
It
Lordship.
has been rejected
Yes,
on
rejected.
the perusal of the case diary.
Yes, Lordship.
And
And
you are
sub-
again approached by this application under section 438,
Yes, Lordship.
concurrent jurisdiction.
Yes, Lordship.
Huh?
Yes, Lordship.
Are you, if you are, saying that it has been wrongly rejected, it's not an appeal.
This is not an appeal, Lordship. This is a subsequent anticipatory bill application before this honorable court. Lordship.
Subsequent, it's not a subsequent bill.
Upon the rejection from the district session, Lordship, we have
Though we
approached.
may have the concurrent jurisdiction, but this cannot be a subsequent bill application.
But Lordship, if I may humbly submit, there is no such bar for approaching again before the High Court under section 438 when the bail application being rejected by the district and session judge, Lordship.
So as the law. Now you are, since you are clear in law, so as the law. On this point. On this point.
Lordship, because
After
well,
this,
why I'm submitting before this one, Lordship, because 438, if I take Lordship to 438 of Court of Criminal Procedure. If I may read, Lordship.
no, it's clear, I'm clear.
Yes, Lordship.
Are you clear? 438, under
Yes.
438,
Yes, Lordship.
both the sessions and the High Court have the
Yes,
concurrent
Lordship.
jurisdiction.
Yes, Lordship.
It doesn't mean that if it is, if if you choose to file an application and before the sessions, if it is rejected, you cannot assail that thing and file a application before the High Court. You may file an application on its own merit. It appears that you are assailing the rejection of the learned sessions court.
Lordship, this is just to suffice this on the court, the ground of my rejection application, Lordship. Lordship, here what I'm submitting, Lordship, is that the enclosement of rejection of my application of Lana District Judge is to show this honorable court the ground of my rejection, Lordship. And here,
So as a law, when the sessions reject your application, then you can file an application before the High Court.
no, there's no such specific. My
There
lord,
is. There is. There are so many.
Lordship, because
What law you are talking about? What clear law you are talking about?
I pardon the
You said
Lordship.
the law is very clear.
No, regarding
You keep repeating that law is very clear.
regarding
What
the
clear
grant,
of law you are saying?
regarding the dealing with anticipatory application, Lordship.
That you don't
Therefore,
have to.
Therefore,
But
Lordship, I was
you-
trying to,
I would like to know, this court would like to know,
yes, Lordship, I may be allowed to put some citations, Lordship,
on
regarding
what?
regarding the Honorable Supreme Court while dealing the anticipatory applications.
That we have come across since last 25 years.
Yes, Lordship, there's no dispute with that, Lordship.
You have to show the law and you have to rely on a judgment, sir,
Yes, Lordship.
on a particular point, not just a general thing. It's just too vast.
Yes.
On what point you want to rely? On which point?
That while dealing in anticipatory Lordship, the accused
You
has,
don't have to.
yes, accused has to
We're
be
not having
presumed
a-
innocence, Lordship.
We're not having a class of anticipatory bail law.
Yes, Lordship.
And neither you are a lecturer of that law,
Yes, Lordship.
nor this court is a student.
Yes,
So you
Lordship.
don't have to lecture on it,
Yes, Lordship. But
right?
yes, Lordship.
what you have to submit on the basis the facts of your matter.
Yes, Lordship, here,
You make your submissions, we'll consider.
yes, Lordship, here, the petitioner, even though FIR were not named. In FIR, the petitioner in this case is not named. And only the police have a reasonable ground of suspicion that this applicant is involved in this matter.
Yes.
Lordship, my humble submission, only on the ground that suspecting the petitioner involvement in this matter does not make it mandatory that a custodial interrogation is required in this matter, Lordship. So far as my name has not been named, and it's subsequently the new development in the compromise deed, it has acknowledged by the victim and the complainant that this petitioner is not involved. The involved was a different person. Therefore, since I'm not involved and acknowledged, and the compensation were already paid by the different person who is involved in this matter. Therefore, Lordship,
According to you, who was the person involved? How
Lordship,
many persons?
Lordship, if I take straight to immediately to the compromise deed, Lordship, it will be very clear to.
Will not consider, they will consider your petition only.
It was alleged that 3 persons were involved in this matter, Lordship.
No interim.
No interim was granted.
Why interim was not granted?
Because there was maybe that they could not convince this court on the first date, you know.
Yes. Continue.
Lordship, here only the ground, I'm again pressing before this honorable court, only the ground of suspecting that I may be involved in this matter. If letting me to be arrested in this matter will not only violate the right to liberty, which is a very precious fundamental right of the petitioner, it will also lead to many great ignominy as well as humiliation in the society, not only to the accused person, but to the entire family who is longing to the accused in this instant case, Lordship. Because the accused is a wage laborer who work and supported the family, Lordship, the wife and a child, Lordship.
Yes.
That is my humble.
That's all.
Yes, Lordship. Because, Lordship, because
you are relying on
I have, in my paragraph 9, I have relied one citation, Lordship. Paragraph 9, Lordship. That is Siddharth versus State of UP 2021 SC, online SC 615, Lordship, where it has stated that just arrest is lawful does not mandate the arrest should be made, Lordship. And in this instant case, being innocent, I'm willing to cooperate upon the granting of the anticipatory bail with the investigation, Lordship.
You have been, notice was given to you to
Notice-
appear on 29 February, 29 February,
Yes,
29.
Lordship, here,
You did not appear.
Lordship, here the petitioner,
As on today, you have not been arrested.
the
You
petitioner,
get a rejection of the bail by
Lordship,
the
here the
sessions.
petitioner are villagers. Petitioner is a
Are you
villager and
absconding now? Are you absconding? Are you absconding?
Lordship, this I cannot say because pending
Obviously,
petition,
you can be
pending,
absconding. By now, you have not been arrested. That means you are
Lordship,
absconding.
Lordship, if this honorable court has granted, they ready to cooperate with the investigation. And
In the case which you have relied is that you are, the accused was cooperating with the investigation. Now, in
and
your
furthermore,
case, you are
and
not,
furthermore, Lordship, I'd like
you are
to
not
submit one.
you are not cooperating with the investigation.
And furthermore, Lordship, I'd like to submit one more citation, Lordship. when the sections are charged 307, 302, and 34 of Indian Penal Code,
Ah,
where the Honorable Court has granted bail,
hmm.
Lordship, despite of having a criminal antecedents in another case. Lordship, if because there is no report that the accused is tampering with the evidence. Therefore, Lordship, on this ground, despite of having a criminal antecedent of the accused, the Honorable Court has granted bail, anticipatory bail to the accused person, despite the charges were 307, 302, Lordship, and 34 and 506 of IPC's, Lordship.
Hmm. Hmm.
And and if I may submit, Lordship, one Siddharam Sarlinga case.
No, you one by one. You tell us this about this case.
Yes,
Punjab
Lord.
and Haryana.
Yes, Lordship, this is
Is it your the allegation that the complaint is motivated?
in this case, Lordship.
What could be the reason of making an allegation against you? What is the reason?
Yes, Lordship, this is raised by the complainant are motivated. That has been found in this case. But Lordship, what I'm trying to submit is that, Lordship, when an accused is not tampering with the evidence and ready to cooperate with the investigation, Lordship, custodial interrogation must be avoided. And it's the same has because the liberty is a precious fundamental right which has been held by the Supreme Court in settling up case, Lordship.
Okay. These are all settled laws. There's
Yes.
no quarrel to that.
Yes, Lordship.
And we cannot have any quarrel on that.
Yes, Lordship, here the petitioner, Lordship, the petitioner is totally innocent. Totally innocent, Lordship. And Lordship, my humble submission is, though Lordship may not take consideration of the compromise deed which has been arrived between the
No,
parties.
that will not take into. Or else you file an affidavit to that effect. This your compromise, which if you are relying on it, we may consider it and we may not rely also. If you want to, you bring on record by filing an affidavit. That's all. That's all.
That is all,
Anything
Lordship.
else?
That is all. Lordship.
Why you are relying this Maheta's case?
Because Lordship, it has been very clearly says that accused has to be presumed innocence until found guilty by the competent court.
Is it so?
Yes, Lordship.
Is it?
Yes, Lordship.
It's a new law.
Lordship, if I take Lordship to my paragraph number 86, Lordship.
It's decades back. That is the settled position. It's a criminal jurisprudence. Criminal jurisprudence.
Yes, paragraph.
Many years back. It's a, since many years back. It's not a new law. New proposition.
Yes, Lordship. This is 2011.
That's why I said I indicate you. You are not lecturing.
Yes, Lordship.
Bell classes in the college.
Yes. I may be allowed to file an affidavit.
Neither I am your. This court is not your student.
Yes, Lordship.
I asked you
seek
to.
an apology,
I
Lordship, for
told
that.
you, indicated you. Whatever you are relying.
Yes, Lordship.
To the point.
Yes, Lordship.
Which you are making.
Yes.
Not all your general principles. Right.
Sorry for interruption.
Yes.
Since Malod, when they said, so Malod, after Malod filing this anticipatory bail application, subsequent development has took place, whereby both the party has already resolved their dispute.
Problem is 307, right?
Yes.
We understand. We respect your compromise and settlement. But 307 involves. No, that's why I'm saying if you want to rely on it, we may consider it or we may not rely on it. But then if you want to rely on those compromise, you file an you bring on record.
My
We'll
lord,
take up the
in
order.
such a matter, we may be allowed to file additional.
Yeah, in this case.
3 days.
Even otherwise, your lordship is well aware of Lakshmi Nara and we are 307 and subsequent apex court's order of Daksa Ben, your lordship. Even-
Malo now press for.
We have not heard her as yet. We're yet to hear her. So it's same.
Otherwise, my lord, so far the.
You are
parents-
brothers.
No, my lord, you are not. My lord. So far the parents concerned, my lord, the concept.
Same
of-
ground, same ground.
My lord.
You are
ground-
seeking-
ground-
seeking-
Ground is not.
Hmm.
I have the defense.
Ah.
I have not on that putting challenging the order passed by the session court.
Hmm.
I am simply here before this honorable court. That so for the fact is that FIR was registered on 31st January.
Hmm.
Thereafter, we have no idea. When we came to know that on 28th January, we have been called by the police under section 41A,
Yes.
whereby 41A said that we must appear before the police. Then only you came to know that the case has been registered.
Yes.
So there is a beyond reasonable doubt, there is a quite apprehension that we are going to be arrested in connection with the Santipur PS case, wherein my lord allegation is 307. In such situation, my lord, we have no other option because the police has no capacity to, my lord, release it. Meaning hereby, my lord, our arrest is confirmed. Therefore, from that day, we are facing, my lord, I have been, my lord, in escorting. And we approached before the session court, whereby the session court is only, my lord said, session court has rejected only on the ground that you are not cooperating. My lord, I am not here against the session court to argue the, what order has been passed. But what I am trying to point out that we are ready to, my lord, cooperate the police. Therefore, my lord, we are seeking anticipatory bail. The moment bail is granted, my lord, from the evening, my lord, we are ready to cooperate the police.
So you are admitting that you are absconding.
My lord, I am admitting I am absconded since when we came to know that case has been registered. Now, my lord, since the lordship has already commented.
It's a good ground to reject your bail application. If you are admitting that, I will give him time, but your bail application will be disposed of now. You are admitting that you are absconding.
My lord,
This is a good, only on that ground, I'm rejecting your bail application.
my lord, on the ground that since, my lord,
So
my case will be-
we'll defer his case we'll take it up on Thursday. You
Yes,
file
sir.
an affidavit. Your case will dispose it.
What?
Huh?
What?
We'll consider this case separately. You said you are absconding.
My lord, this is undisputed. When, my lord, police is searching, my lord, when the person is, my lord, applying anticipatory bail.
No,
my
I'll
lord,
record that the learned counsel for the applicant petitioner has admitted that the accused is absconding. Therefore, though he is apprehending arrest, therefore he is absconding.
My lord, I am apprehending of arrest.
Yes.
Therefore, my lord, I am appeared before this honorable court. I may be protected because I am.
But you are absconding. You are absconding.
Because, my lord, I am serviceman. I, my lord, because, my lord, I am responsible person. Because, my lord, if I appear, happen to be, my lord, I will be arrested and, my lord, there will be, my lord, the.
You may have that apprehension, but if you appear, then you may not be arrested also.
My lord, utility where, my lord, this record has already been shown, my lord.
Hmm.
Here, wanted, my lord.
It
Would
depends.
Before confirming that, my lord, the circulation has been.
If you are
made.
really innocent, definitely we're sure that you will not be arrested.
My lord, if my lord go through the, my lord, this subsequent agreement, my lord, is completely, my lord, my innocent is revealed. In fact, my lord, I am taking the.
Compromise with whom?
My lord, here.
Compromise with whom?
compromise with my lord the informant and the victim.
Victim.
Whereby my lord, it is clearly reflected that the person who involved in the crime, my lord, admitted that I was not here. I
Okay.
have been, my lord, only alleging, I have been, my lord, down on the ground that on the same day before the incident, I was with him, my lord. But on the suspicion that has been, and there is, I hope that my lord, in the CD also.
So
there is
according to you,
nothing
according to the real the accused or the perpetrator is been identified.
identified,
He has been arrested.
not yet been arrested. This
Yeah.
is the other person. And-
So
and
he's also absconding.
my lord, that I have no idea. I have no idea. about it. So, other
okay.
such situation, ma'am.
Yes, your lordship, your
What's to
lordship
be
is,
done?
your lordship, if your lordship may take up even the matter even today, your lordship is well aware that in a bail application, your lordship, if even if the party compromise, your lordship, that would not be a ground for bail, your lordship.
Mm.
The other part, your lordship is well aware that the FIR was filed on 31st. Thereafter, investigation was proceeded, your lordship. Your lordship will see that the person, the victim was beaten, taken to the jungle. Even his mobile phone was taken, your lordship. During investigation, through his mobile tracking, your lordship, it was found that one of the accused has called his friend, your lordship. Subsequently, sources were put on, your lordship, to identify, and therefore, three of them were identified. And since full effort was made to locate them, your lordship, they could not come, and therefore, this wanted circulation was made, your lordship. Now, your lordship is well aware that even under 307, even if they come with an agreement of compromise, your lordship. The other situation here is, your lordship, as per my, even in the CD and my information, your lordship, they have put upon the pressure upon the investigation through student unions, your lordship. They have come to the police station on many occasions, threatening even the police, your lordship. And that's when this
by
come
whom? By whom?
by the both by the accused, your lordship. They have involved all these student unions, your lordship. There has been, and that's how this compromise has come into existence here.
We'll take it up towards Thursday.
Yes, your lordship.
Whether that's why I said they are harping on the compromise settlement deed. Let them bring on record. We'll see
Yes.
how far it will help you. The CD is there
Your lordship may retain the CD. I have produced the originals.
on the prayer of Mr. C. Modi and Mr.
G. Yobin, Lordship.
G.
Yobin.
Yomi.
Yobin. Yobin.
Yoming.
Yes.
G. Yoming.
Yobin,
Yobin.
Lordship.
G. Yobin. Learned counsel for both these cases, 16. Petitioner, applicants. List this matter on 20.
21.
Thursday, 21.
20.
Or next week,
21, your lordship.
21. 3/20/24. So as to enable them to file additional affidavit. Mr. MST Jenny Learned additional PP present. Case diary be retained. Diligent.
Deeply blush.
Your lordship, in item number 20, your lordship, the counsel for the petitioner has not been appearing on many occasions, your lordship. So on the last occasion, when the matter came up on 1st of March, your lordship, this court has an opinion that amicus curiae may be appointed.
You cannot dismiss for default.
Yes, therefore, your lordship.
This then. This is transfer of criminal case.
Yes, Your Lordship. Transfer of the trial from JMFC Inkyong to District and Sessions Court UPA.
Can we direct the registry to
Appoint
issue,
a number.
notice to the petitioner?
That can also be done, Your Lordship.
Or MS TJ learned edition PP. Appear for respondent number 1.
1 minute.
It is seen that the for last 2 consecutive occasions non-represented the petitioner. Today also and no steps has been taken by no steps been taken for service of notice upon respondent to this next one. The registry is directed to issue notice to the petitioner. List this matter after 4 weeks.
4 weeks.
Then would be the
Yes.
appropriate, but then let us see.
Yes,
Let
Your
the
Lordship.
registry issue a notice to the petitioner.
Yes. Deep.
What is to be done today?
Your Lordship,
On last occasion, the respondent, they were supposed to file objection. When is affair today?
You have received the LCR.
Yes.
LCR is there.
Lord, this is the petition under 482 CRPC.
Have you filed the objection?
No, Your Lordship.
Objection is really required. Offense,
Offense 448, 323, 341, 34 IPC.
what is the ground of what is ground you have taken?
Lordship, in the instant case, there is no any prima facie evidence that this the alleged expression is to be prosecuted under the section invoked. There is no case at all. The prosecution has failed to made out.
You are appearing for 4 and 5.
Respondent number 4 and 5, Your Lordship.
Are you ready?
No, Your Lordship, kindly short date may be given, Your Lordship, for objection reply, Your Lordship.
You are a time.
Yes, Your Lordship.
You have prayed for consideration of the matter today, final consideration.
Yes, Your Lordship. Since the main council are out of station, Your Lordship, so kindly short date may be given, Your Lordship.
I will give you a long date. What's there? Is the interim order staying the proceedings?
Yes, Lordship. Yes, interim is there, Lordship. And Lordship, there is a one same petition arising out of same FIR. This is Pechi Boy, 225, and this is 224, I think. So both the matter may be heard together.
Mr. Learned Counsel for the Bills. MST Learned Additional PT for this state. MS A time
Yes, Your Lordship.
Learned Counsel appearing for on behalf of respondent number 4 and 5. Respondent granted 2 weeks time to file objection if so advised. Objection, list after 4 weeks.
Interim may be continued, Lordship.
Be continued and LCR, scan copy LCR. Be
Lordship,
Be
may
retained.
direct registry to list about the
List
matters
this
together.
matter on after 2 weeks along with criminal petition so and so.
Two-
so and so.
225,
Just keep that
22.
up. Huh?
Deeply.
Hmm.
My lord, I am
I may
appearing.
not take up this matter. I think. What is the other say? There may be difficulty in taking up this matter.
My lord, counsel for the petitioner is also out of station. ma'am. He informed,
Only prayer, Mr. M. Doji, London Council for the petitioner.
I am for the respondent, man.
Respondent. List this matter of 4 weeks.
Obliged.
Yeah, my lord. Well, this is quashing petition, my lord.
What is the offense?
My lord, offense involved with section 326 IPC, my lord.
Huh?
326 IPC, my lord.
326.
Yes, my lord. My lord, if before going to the fact of the case, my lord, if rightly remember, my lord has quashed a similar nature offense that took place in 2019 Assembly and Parliamentary simultaneous election.
Huh?
Where, my lord, offense related to that took place between two factions of rival MLA candidate in the year 2019 during parliamentary and this assembly simultaneous election. My lord. That judgment I have annexed is annexation number 6, my lord. That is annexation number 6, my lord. Page number 68. We start from page number 68, my lord.
It's similar matter.
Almost similar, my lord.
Same FIR.
Not my lord, same affair.
Then?
FIR is different, my lord. But this offense took place at same event, my lord.
Same village.
Same village, my yes, my lord. Same village. A victim are different here, my lord. But accused in both the cases are same, my lord.
Huh?
Accused in both the cases are different, my lord. Accused victim are same.
Victim are different.
Victim are different, yes, my lord.
Accuser same.
Accused are same, my lord.
So.
But
the
FIR,
Hmm.
FIR is in page number 14, my lord. Tab 14, my lord. Page number 14. Oh, my lord. Complaint against so and so. I propose to the opposite side is subject. I would like to inform you that on so and so I had gone to JK village to cast my vote in the election and stayed at the house of Sri so and so. On that date, so and so a group of people attacked the house of so and so. However, I thereafter tried to proceed to my village, going to see whether my family members had come to the village from Daporja. However, as I had stepped out of the house and gone a small distance, two persons named above came rushing towards me and started to hitting me with stick and rod. And during the course, I have been severely injured. The said attack was done without any provocation and they tried to kill me. However, some persons intervened and rescued me from death. Therefore, you are requested to book the said persons under relevant provision of law. And my lord, thereafter, my lord, charge sheet was filed, my lord, under section 341, that is wrongful restraint, 326, that is causing grievous hurt, and read with 34 IPC, my lord. Now, my lord, this alleged accused person and this victim, they are from same village, my lord. And they are clan brothers, my lord. They have amicably settled their, my lord, disputes, my lord. So that's why, my lord, they have executed agreement that the 28th October 2022, my lord. So, my lord, on the basis of canon of judgment laid down by the Honor FX Court, my lord, this since matter being private in nature, my lord, and they being already settled the dispute, my lord. So my humble plea is, my lord, matter will be set aside, my lord. Criminal proceeding will be set aside, my lord.
Is there material against the accused, the charge sheet?
Yes, my lord, materially,
You have attacked.
it is, my lord.
You have attacked.
My lord.
You have attacked the victim.
Well, that is their allegation, my lord. That is their allegation of the victim, my lord. And my lord, may fair use space number 71, my lord. That is, my lord, judgment, my lord. Is number 71. But here also space number 70, my lord. Here is also allegations is almost same, my lord. Page number 70, para 4, my lord. The genesis of the matter emanates from the fact that on so and so an FIR was lodged by informant against petitioner number 127, alleging that on so and so during the assembly and parliamentary election, while they were at village JK, around 50% led by accused person surrounded the house of the informant either on so and tried to enter the house and attempted to kill them. And again on so the same group, the accused person surrounded the house of the informant armed with dowels and a stick.
Oh, this was during the election, but then here FIR doesn't reflect anything.
My lord, FIR page number 14, my lord. FIR already is status, my lord.
Huh?
It is there in the FIR, my lord. Is
Page
there
14.
14, my lord.
During parliamentary election.
Yes, my lord.
Where it is?
Yes, my lord. Page number 14, my lord. Type copy. I propose to the cited subject, I would like to inform you that on so and so I had gone to JK village to cast my vote in the election. And he said so and so, my lord.
It's a joint petition.
Joint petition, my lord.
Why is there?
Sorry, your lordship.
Next election is coming.
Yes, I will leave with your lordship.
If it's out of same
Yes, same area. Your lordship has
wrongly or rightly, this court has also.
yes already watched the matter, and your lordship, if they have settled the matter, no doubt, your lordship. Otherwise, so far as the position has been recorded, so but since they have approached the court is squarely on the basis of settlement. Considering that aspect, your lordship may interfere. However, if we see the material, the record on deposition, it shows that yes, some materials are there, your lordship. It cannot be directly said that there is a remote and bleak chance of conviction, but to prevent the abuse of process, your lordship may.
But then it was serious. Injury is so serious.
326, your lordship, it's a grievous injury. And punishment is up to life, your lordship. Minimum is not prescribed, but it will fall under the category of serious offense, since minimum should be 7 for heinous.
Of course, I understand this depends on the, maybe same time, same village, same person, but it depends on the material.
Yes, ma'am.
Anyway,
Okay.
how Mr. L could learn counsel for the petitioners. How many petitioners?
Three, my lord, three.
Huh?
Three, my lord, three petitioners.
1 and 2 are accused person and 3 is the informant victim.
Informed victim.
And also had Mr. T at the London Edison people. This is an application under section 482 of CRPC, 1973. Going for washing of the Purja. I would say washing of the criminal proceedings.
Yes, your lordship. Criminal proceeding
Criminal
pending before
proceedings,
this.
Under section 341, 326, public 34.
Yes.
Charge sheet
Yes.
has been filed.
Yes, sir. Trial commence, your lordship.
341, 326, 34.
Yes, your
Not
lordship.
307.
307 not charge sheeted. Initially, it was registered under 307.
Anyway. So we're on questioning of the criminal proceedings
Yes.
arising out of Dapur PS case number 20 of 2019, pending before the Chief Judicial Magistrate. And criminal proceeding being GR case number 33 of 2019. Then you write under section so and so, pending before the arising out of so and so, pending before the criminal, Chief Judicial Magistrate, Dapurja, on the basis of the settlement between the parties. First line uses this is an application under application jointly filed under section, The petitioner 1 and 2 are the informants, the accused, and the petitioner number 3 is the victim, informant of the victim. Next page. The case in brief, is that an FIR was lodged on 12/4/2019 against the petition number 1 and 2 by this petition number 3, alleging that on 10/4/2019, when he had gone to JK village to cast vote in the election, Mr. And ten for 2009, he had gone to JK village to cast vote in the election. Mr. Thereafter, he proceeded to his village and to find out whether his family members had come from the origin. And the moment he stepped out of the house and gone little further a distance, two persons, and they were both the petitioners. Petitioner number 1 and 2 came rushing towards him and attacked him with sticks and poles without any provocation. Thereafter, on the intervention of some other persons, the petition number 3 was saved from further injury. The according to the Furuja PS case number 2019 was registered, and on completion of the investigation, charge sheet number 18 of 2019 and the section 341,
Yes, madam, 341 and 326.
341/326/34 IPC was submitted on 13/7/2019 before the Chief Judicial Magistrate in the GR case number 33 of 2019. It is seen that the no, charge sheet was 307,
Yes, yes.
324,
No, your lordship,
325 and 34.
326.
Charge sheet under section 307/326/34 of IPC, yeah. Initially, yeah, charge sheet against the petitioner number 1 and 2. Mr.
Charge sheet, my lord,
It will remain.
307 is not there, my lord, charge sheet.
Charge sheet,
Yes.
307 is not there.
Not there, my lord. Page number 15, my lord.
But you have said so, paragraph 4.
Your lordship, in charge sheet in page number 19, your lordship will find the charge sheet. Therefore, I am submitting charge sheet against both alleged accused to face trial 341, 506, 326, 34 of IPC. Did
Then
the
in it,
charge?
you delete that, huh? Charge sheet under section, 341, 326 or the 34 IPC.
506 as well.
506 also.
Yes, page number 19, your lordship.
506. Then charge has been framed.
Framed, yes.
34503. Yes.
Charge frame under section 326 and 34.
Not even 341.
Yes, your lordship.
Okay. The Chief Judicial Magistrate has framed the charge. When the charge was framed?
Charge was framed on
Where it is?
on 20 March 2020. Your lordship, and 4 sections were there, your lordship. Your lordship will find it in page number 48. Lordship mechanism. Type copy. 348. Partially, so and so, restrain Marwa, so and so in furtherance of common intention, thereby commit an offense punishment 341, 34 IPC within my cognizance. Secondly, so and so, voluntarily caused grievous hurt to Tala Marbo by means of instrument, iron or rod, which is used instrument, so and so.
Same thing.
Yes, 326, 34.
Hmm.
Three sections only, Your Lordship, 341, 326, and 34.
Frame the charges against the petition number 1 and 2 and the section 326, 341, oblique 34 of IPC.
Yes.
How many witnesses? PWS.
Page number 49.
Mr. Could learn.
15 witnesses.
Huh?
15 witnesses, all total
So
15
all by-
PWs.
Find out 9 have been
Yes, examined
examined.
out of 15.
The could learn counsel for the petitioner submits that the dispute being purely family matter, the parties have settled their differences amicably and entered the settlement deed on 04/110, 4th of
4/10,
October
22.
2022, which has been before the executive magistrate Naharlagun. By Naharlagun, if it's in Daporijo,
My lord. 61.
he submits that in view of the settlement among the parties and differences arises due to family disputes. And now the petitioners are living peacefully. The continuance of the criminal proceedings in the present case would be abuse of process of law and must, in as much as there is a public stance of conviction. Therefore, it submits the criminal proceedings being their case so and so, 30 of 2019, pending before the learned judicial magistrate, that will be quashed. Next page. What is your submission? Mr. T at learned judicial PP. What I should record your submission?
Lordship, since they have settled the matter, that will amounting to abuse of process. For ends of justice, Your Lordship.
However, you are saying that there's a material.
The material, although the materials are there in the deposition as recorded.
But submits there, although there's a materials against the petition number 1 and 2.
Yeah.
As recorded and submitted in the charge sheet. Since the matter have been matter have been settled between the petition number 1 and 2 and petition number 2, they being the same clan member.
Clan member is to maintain cordial relationship.
to maintain cordial relations and for the interest of the family. Come on. The continuance of
Yes.
the proceedings may be a abusive process of the
Yes.
Mr. Before. Does, come on, he submits that this court may was appropriate orders. On the attending facts and circumstances of the present matter. Mr. Next one. I have considered, the due consideration has been extended to the submissions of learned counsel to the parties, and there is the case diary. Case diary is there.
No, Your Lordship,
Case diary.
perhaps the LCR, because it's already been, trial has already been commenced, Your Lordship.
Huh?
Trial has already been commenced. LCR maybe there in the
No,
court.
case diary is not there.
No, case there is not there.
It was not called for also.
Yes, Your Lordship. Trial commenced, Your Lordship. So CD.
No, not case diary.
LCR.
LCR.
No, Your Lordship, LCR is not there. It's in,
It be appropriate. Why this has been fixed for final hearing?
But Your Lordship, considering the material so annexed, because they have already annexed the case diary and the deposition, everything, Your Lordship, considering the expected.
Now, my lord, since
And
interim protection is
consider
also
the
due.
materials available on record, which is the next to the present petition. Next para. Are you getting it? Little bit. All wasted. You could have pointed out if it is not clear. I told you are comfortable. And dictate in the chamber.
Okay, Your Lordship.
I cannot go back. If you are not clear, you could have. We'll pass that.
Okay.
Obliged, my lord.
Obliged.